guys, this is Muskan. I am legal intern at LEXCLIQ and Company. So today's topic of discussion is judicial separation in India. So let's proceed with our topic. Judicial separation is the period that comes before divorce. It is a period of separation mandated by the court before the divorce proceedings can be stated. Under all personal laws, the judicial separation period is for 1 year. The period of judicial separation is 2 years and gives time for introspection and resolving the matrimonial disputes and misunderstandings between the couple. In India, a marriage ceremony is considered to be one of the most essential arrangements between a man and a woman. The religious duties of marriage, according to second Hindu religion, is that of a permanent connection between the husband and the wife, which is unbreakable and endless in nature, valid not only for the present lifetime but for the next lifetimes to come in the future. This ceremony is thus performed with utmost religious practices and rituals. However, it can clearly be determined that under this ancient regimen of a marriage, there existed no form for any consent of either of the parties regarding practical and day-to-day issues which may occur during the tenure of the marriage, which are well beyond religious customs. Thus, the Hindu Marriage Act was incorporated in order to provide justificable rights to married individuals, and it even gave options for revoking said marriage under specific sections with limits and bounds, which either parties are free to consider. Section 12 of the Hindu Marriage Act provides that any marriage is voidable if the following conditions are satisfied. So, first condition is either party is impotent or unfit for procreation of children. Second, conditions given under clause 2nd of section 5 which are given below. First is when either party gives consent in the form of unsound mind at the time of marriage. So, second, capable of giving a valid consent as such unfit for procreation of child while he or she has been suffering from mental disorder. So, third, either party is subjected to the habitual attack of mental disorder. In case the marriage occurred without the consent of the bride or her parent or guardian and under undue pressure. If the bride was pregnant by another man other than the bridegroom at the time of marriage. Moreover, Section 11 of the Hindu Marriage Act 1995 provides that a marriage is void if the clauses 1st, 6th, 5th of Section 5 are not satisfied. The clauses are given below. Either party should not have any other living spouse at the time of marriage. Either party should not fall within the degrees of prohibited relationship, or either parties not fall within the degrees of spindle relationship. So now, what are the grounds? What are the grounds of judicial separation in India? On basis of which grounds judicial separation will be granted? So there are many grounds. Few of them I will discuss. Cruelty, desertion, adultery, forced conversion of religion, incurable disease such as cancer, Ebola, etc. Insanity, vulnerable disease, rape, sexual harassment, renunciation of world, child marriage, etc. So let's discuss one by one. Cruelty, either of spouse or both are cruel for one another. Desertion, either of spouse is not alive and is missing since 7 years and above. Other is adultery. Either of spouses is being cheated upon by other spouse. In case a husband or a wife knows that their respective spouse is married and that other person is alive during this petition, then the grounds for judicial separation stands. Next is forced conversion of religion. Either of the spouse is forcing the other one to change and convert her religion. Incurable disease such as cancer, Ebola. Insanity or abnormality, either of spouse is not in a sound condition. Vulnerable or sexual disease, either of spouse is suffering from sexual disease such as HIV, AIDS, etc. Rape, sexual harassment, renunciation of world by either of a spouse, child marriage, either of spouse is married without her consent before turning the 18 years of age. So all these are then difference between judicial separation and divorce. So we discussed the difference between judicial separation and divorce. Judicial separation does not terminate the marriage, whereas in divorce the parties are no more husband and wife, hence the marriage ends. While undertaking proceedings for judicial separation, the court does not have to consider that the marriage is permanently closed or broken down, whereas in divorce it is required while presenting the petition. Both the parties can file for judicial separation at any time post marriage. Whereas in case of divorce, the parties can only file for divorce only after completion of 1 year of marriage. A judicial separation goes through one state judgment procured, however, divorce goes through a two-stage judgment process. There are certain provisions in Matrimonial Clauses Act 1973 that are applicable to divorce but are not applicable to judicial separation petition. This is irrespective of going through a 2 or 5 year separation period. Judgments with respect to wills and not applicable in case of judicial separation. In case the parties are undergoing a separation time and if one of the spouse dies, then the existing spouse will not benefit out of it, and thus the property will devolve. Hence, judicial separation is a process wherein the court provides a final term to couples seeking divorce to try resolving their differences by living separately before the initiation of divorce proceedings. This gives time for introspection and resolving the matrimonial disputes and misunderstanding between the couple. So that's all. So if you like my video, please do like, comment and subscribe the LEXCLIQ YouTube channel. Thank you.